heard appeal in the matter of AGPS BondCo and Strategic Value Capital and others.
Yes, good morning, Mr. Smith.
Good morning, my Lord. My Lord, when we finished yesterday, I was in the process of dealing with ground 4, which is the question of whether divergence from pari passu was justified or not.
Yes.
I dealt with one of the key ways in which planned divergence from pari passu, which is the maturity date. I'll deal now, if I may, with the other key way in which the plan parted from pari passu, which was the priority security given to the 2024 sons, and also the priority security given to the convertible notes, which took place as part of the wider restructuring linked to the plan. By way of recap, as your Lordships will recall, the way the security structure was left following the plan is that the first priority security is for the new money. There's then second priority security for the 2024 sons and the convertible notes, and third priority security for the remaining sons. So the key point is that in terms of the priority of the security...
Is there any security for the sons?
For the...
Sons, the remaining, you said...
Yes, they get third ranking security.
Right.
So essentially it's in 3 tiers: new money, 2024 sons and convertible notes, and then the remaining sons. So the objection from our perspective is the greater priority given to the 2024s and the CNs vis-a-vis the remaining sons. And we say there was no good reason or proper justification for that departure from the pari passu approach either. In terms of the judge's approach, he dealt with this in paragraph 306 of the judgment, so core bundle 2, divider 5, page 902. Paragraph 306 is really the key paragraph. In a similar way to the way in which he dealt with maturity dates in paragraph 302, the way he structures it is essentially to have a number of points which he has identified as being relevant to and supporting his conclusion. At the outset, you can see from the opening sentence of paragraph 306 that he frames the question which he asks himself as being whether the priority given to the 2024 notes means that the plan is so flawed that the court should not sanction it. Now, in our submission, that was the wrong test, and consistent with what the judge had himself stated in paragraph 74 of his judgment, he should have asked himself whether there was a good reason or proper justification from the departure of pari passu treatment between the sons. And if he had asked himself that question, then the clear answer in our submission was that there was no such good reason or proper justification. The short point is that the objectives of the plan plainly did not require that priority security be given to the 2024 sons or indeed to the CNs. Now, the nearest one gets in paragraph 306 to a justification for the divergence from pari passu is what the judge says in subparagraph 2. And you can see what he says in subparagraph 2. He says the plan involves an extension to the maturity dates of the 2024 notes, but not to any other series of the sons. The quid pro quo for the agreement of the 2024 plan creditors to this extension is to give the 2024 notes priority over the other sons. Now, he says there the plan involves an extension to the maturity dates of the 2024 sons, but not to any other series of sons. Now, in a sense, you might say that is correct, because it's only the 2024 sons that had the contractual maturity date extended from 2024.
What is their maturity date?
Under the plan.
No,
July 2025.
No, under as a matter of contract.
But prior to the plan, it was a date in 2024. I can't remember the exact date. July 2024. So effectively, it was pushed on by a year from July 2024 to July 2025. Was
there any exploration of the date at which the companies would go into insolvent liquidation under the relevant alternative?
At that, before the judge at the trial. Well, no, I mean, I don't think that point was specifically investigated in any depth. I think it was assumed it would happen
Imminently.
Yes.
Well, that was the question I asked yesterday.
It was imminent. It was assumed it would happen imminently, and that was the whole reason the proceedings were very heavily expedited, was to get an order.
Well, there was the 400 million Adler RE debt falling due in April.
Correct.
Was it assumed that if that could not be met, i.e. if the new money hadn't come in by then the balloon would go up and insolvency would follow it within days?
Yes.
Yes.
Exactly.
So there's no realistic prospect of the 2024, under the relevant alternative, of the 2024 notes actually being paid out
before liquidation.
Before liquidation.
No, none whatsoever. That has never been suggested, and in our submission, couldn't be the position, because it was the plan company's own case. That unless you do this now, i.e. sanction the plan, we're going to go into liquidation. Now, just to go back to the point here, as I say, in the sense what the judge says is technically correct, but in our submission, again, he misses the key point, which is that the alternative to the plan was a formal liquidation, and that in that liquidation, all of the sums would have been accelerated and would have ranked alongside each other as presently due liquidated debt. And this is, we would suggest...
We're not actually paid in July 2024. When they would be paid in the relevant alternative would depend upon how long it took for the liquidators both to market and sell, realise the assets, and to complete the liquidation to a stage at which they could make an interim distribution.
Exactly right.
And there were some assumptions as to that in the BCG comparator report.
Oh yes, there were, exactly. And you can see as part of BCG's analysis as to how the realisations would have gone in the liquidation, they set that out, exactly right.
And I think it was some date in 2026.
Exactly.
The first distribution.
I think your lordship's right, yes. But the point, I mean, in essence, this is a theme one sees in the judgment, where the judge in our submission consistently falls into error, because he focuses on the contractual maturity dates. But really what matters in relation to this plan, where the alternative is a liquidation, is what the position is in the liquidation. And if you look at the position in the liquidation, the reality is all of the notes are being extended, because rather than having a presently due accelerated debt, which ranks pari passu, they're all being extended out by reference to that starting point, but by different degrees. And we do submit that the judge, you see this here, you see it elsewhere, he takes his eye off the ball by looking at...
Why do you say they're all being extended?
Because in the liquidation, all the debts are presently due and payable. Due and payable, when they're in fact paid depends on the realisation.
Yes,
but they're all present.
When you say extended, that would suggest a later maturity date. But they have an earlier maturity date, but then they're paid out in the course of a liquidation.
I think you're actually agreeing with my lord's earlier point. I don't want the two of you to.
I think we are. So in the liquidation, all of the sums are accelerated to a presently due debt.
Yes.
Which is then due and payable.
Yes.
As at the date of commencement of the liquidation. They're then in fact paid out as and when realisations are made. But in terms of the due and payable date, in terms of the accruing of the cause of action, that's as at the date of commencement of the liquidation.
Yes, but that's not an extension, that's an acceleration.
You were talking about extension in the practical sense of when paid as opposed to payable.
Yes,
I think.
So that's not an extension, that's an acceleration. That's the position in the relevant alternative. What happens under the plan is an extension relative to that, if that makes sense.
Oh, I see.
That's the point. I'm sorry, it's my fault for labouring it, but that's the point I'm making. And in relation to that, all of the sums are extended by different degrees.
Compared to the immediate due and payable in the liquidation.
Exactly. And in our submission...
so slow.
No, it's my fault. I'm sorry. I'm not being as clear as I might be.
It's not the extension, is it, of itself that matters, because after all, I mean, if, for example, they'd stipulated a maturity date under the plan, let's say in 2025, for everybody.
Yes.
I mean, there would be, I mean,
Yeah.
obviously there's an element of extension over the position under liquidation on that basis, but you wouldn't be complaining.
We wouldn't complain about that. No, your lordship's quite right. I mean, it's not the objectionable feature isn't the extension per se. It's the, if you like, the differing extensions. To use the terminology of extension applied to the different sons. But I mean, the point I was just making here is the judge's reasoning. He references it by looking at the contractual maturity dates, and that just isn't the relevant question here. What you should be comparing it to is what the treatment would be in the relevant alternative, which is the insolvency. So he just gets off on the wrong footing by looking at the wrong question in our submission. And that, as I say, you see it there in 3062, you also see that same point elsewhere in the judgment. Now,
just before you leave 3062, what do you understand him to be saying when he says they were being asked to agree to an additional element of risk?
well, I think he just means the extension of the contractual maturity date by a year. So you've effectively got your debt outstanding for another year.
But that forgets the fact that the relevant alternative would kick in before the actual due date for the 2024 notes. That's your...
Exactly, that's my point. So he's looking at the wrong comparison, basically. But I mean, I understand that's what he's seeking to say here. But it's just the wrong comparison. He's looking at the wrong... He's comparing it to the wrong thing.
Yeah, and he goes on, and lock up their funds for another year. That means, I think colloquially, that means not get paid for another year.
Yes.
But he's missing the point. You say that actually they weren't going to get paid even on the due date, never mind locking up for another year, because the relevant alternative is a liquidation which kicks in 2023, not 2024.
Exactly right.
That's your point.
Exactly, my lord.
Exactly. It is the point my lord made yesterday about re-hawk. What is the relevant alternative? And
yes, that's critical.
It is insolvency.
Yes. The question of what the relevant alternative is absolutely critical. And that's why we say this case turns on the facts. And the facts of this case are that the relevant alternative is a formal liquidation. It would have been imminent. Everyone would have been treated pari passu in that. And it's that actually drives, or ought to drive, the analysis. But the judge has, as I say, taken his eye off the ball, we would suggest.
I mean, your argument, I think was really is that there was, to use the judge's word, an additional element of risk for everybody.
Yes.
Over the, I mean, if the comparison is with the position under a liquidation, everybody was had to take on an element of risk insofar as they were postponed beyond a notional liquidation date.
That's right. But we took on more by being postponed the most.
I understand that.
Exactly. No, absolutely. Now, just to deal with the security given to the convertible notes, the plan company claimed that was justified because the convertible notes contained a negative pledge. And they said, therefore, we have to give the convertible notes the same security as it's been given to the 2024 sons in order to comply with the negative pledge in the convertible notes. That's not a brilliant reason as a starting point, because it takes as its premise the fact you treat yourself as having to give security to the 2024 sons in priority to the other sons, which in our submission is not the correct starting point. But in any case...
But the convertible note holders are not plan creditors.
They're not. But it's something that takes place as part of the restructuring linked.
But how do you bind them into this arrangement?
Well, this is what if I can just come to that in a moment, because that's essentially the point my learned friend makes.
Are we about to get into a point which is that when you are assessing the fairness of a scheme or a plan, which forms part of a wider restructuring, you do not just confine yourself to the literal wording or terms of the plan or scheme, because that would be too narrow a focus. You have to look at the wider restructuring, simply because it's a matter often of choice, exactly how people tend to do the restructuring, how narrow. The scheme itself is often just, you'll just enter into some other documents.
Exactly. I mean, it's a point I think your lordship's made once probably in
I'm sure I have,
other
I'm
cases.
afraid.
But yes, and in fairness, I don't think that point is. No. I don't think it's.
And to be fair, to myself, I think Mr. Justice David Richards, as he was, made the point at the start. I think in a slightly different context, but basically saying you don't just narrow your focus to the.
That's right.
Terms of the plan or the scheme.
Yes, exactly. And I say I don't think it's suggested that by my friend, that you wouldn't take it into account. I mean, what they said first of all was, well, we have to give security to the convertible notes because there's a negative pledge in the convertible note, and if we're giving priority security to 2024s, we have to do the same for the convertible notes. As I say, not a good reason, because it assumes that you're bound to give the priority security to 2024s, which is not right. But in any case, it's also not a good reason, because we pointed out that the sons, all of them, in fact, contain exactly the same negative pledge. So the same reasoning applies in relation to all the sons. Now, what was then said was, the point my Lord Justice Nugee adverted to, was it was said, well, we can't bring the convertible notes within the plan, so we can't amend their negative pledge in the same way that we can amend the negative pledge of the sons who are within the plan. So it's effectively saying we're bound. And obviously that's notwithstanding that the sons themselves had originally been issued by exactly the same entity as had issued the convertible notes, Ad Hoc Group SA. So this problem arose entirely as a result of the group's own making by switching the issuer of the sons from Ad Hoc Group SA to the plan company. So it was a problem actually they created themselves, but they then sought to take advantage of it. But as we say in the skeleton, in our submission, it's not, in any case, a great point. And as we explain in paragraph 39.3 of our skeleton, page 954, they could have brought the CNs, the convertible notes, within the plan. And the way that can be done would have been for the plan company to issue a deed poll, assuming joint and several liability for the convertible notes. And on that basis, the English courts, certainly at first instance, have accepted that it's possible to compromise and vary the obligations that are effectively the subject of the deed poll.
The convertible notes are presumably governed by German law.
I assume that's right. But in our submission, that's not the evidence was that the plan would be recognised in Germany.
I thought that was slightly contentious, the deed poll route.
Well, what's said now in relation to the deed poll point, it said, well, if we'd done that, there's risk of the deed poll being disclaimed by one of the holders of the convertible notes. So they now say, well, notwithstanding they created this problem, notwithstanding you can deal with it by deed poll, we couldn't have done it because there's the risk that a convertible note holder might have come along and said, well, I'm disclaiming the deed poll and therefore it doesn't work. But there isn't any evidence that any convertible note holder would have disclaimed at all. It has been done in previous plans on the basis of the deed poll arrangement. Gate Group is one example of that. I think a Kadire case, which my Lord dealt with at first instance, is another example. So we don't accept that it wouldn't have been possible for the plan company to do it.
But my Lord is right, all those structures, all those sort of adherence structures, deed poll structures, are, they have been done at first instance.
Yes.
But they are not blessed by any form of appellate authority.
Correct.
After contrary argument.
Correct.
And a number of judges have said from time to time, this may be jurisdictionally permissible.
Yes.
In the literal sense of the statute.
Yes.
The artificiality of that type of arrangement is up for grabs, if I can put it that way.
That's a fair summary, if I may say so. I mean, that is where the first instance authorities have ended up.
I don't remember in Kadir, which was only the composition hearing,
Convening hearing, yeah.
convening hearing, having any argument at all about disclaimer.
No, I don't think there was argument about disclaimer. It was just a deed poll case. I don't think the English court hasn't yet dealt, apart from the Gate Group, where there was a disclaimer but it was then in effect withdrawn. The English court hasn't yet had a case where it's had to deal with argument about the effect of disclaimer.
It does seem quite odd, if one stands back, that somebody can have a liability voluntarily assumed in their favour and not be able to say, well, I don't want it.
Yes. Well, I see that. And I don't want to get too... This is obviously a fascinating point. I don't want to get too sidetracked into it, because the short answer in the present case is that if you go to 309 of the judgment, having canvassed the sort of pros and cons of whether it would have been possible to bring the CNs into the plan, the judge didn't, in fact, decide the issue on that basis. As he says in paragraph 309, I think he thought there were probably points of contention both ways, and as he says, I didn't hear full argument on this point, and I would be reluctant to decide the issue on this basis. So it doesn't, that point now raised by my learned friend doesn't in fact form part of his reasoning in deciding this issue. What he in fact relied on were the points set out in paragraph 310. And I should say there isn't a respondent's notice on this point saying that he should have decided it on the fact it wouldn't have been possible to bring the convertible notes into the plan. What he did decide it on is the point set out in paragraph 310. In our submission, those don't stand any scrutiny at all. I mean, the first point is that the face value of the convertible notes is a small amount of the overall debt. Well, I mean, that's true as a fraction, as a percentage, but it's still a rather large sum. And in our submission, it can't be an answer to this point to say, well, actually, it doesn't matter that we're giving priority security to this debt, because actually, although it's 165 million, the overall debt pile is quite large. I mean, that isn't a reason why it's fair to give priority security to that debt.
No, but it does mean it makes very little difference to your percentage return.
To the economics, yes. Well, possibly. I mean, you're putting 165 million euros of debt ahead of us, where we're 800 million euros. So instead of ranking pari passive with 165, we've got 165 ahead of us. It's not immaterial, I would suggest. I mean, the temporal priority point he makes in our submission is again wrong, because he's looking at the position not by reference to the relevant alternative, where all of the debt, including the CNs, is accelerated and ranks pari passive. Again, this is an example of the judge taking his eye off the ball and looking at the wrong comparator. And then I've already dealt with why the honest, intelligent person test can't itself be an answer to cross-class cram-down and the issues that raises. That was our ground 2. And then, essentially, he just refers back in this final point to the reasons that he's given in relation to the 2024 sons, which, again, as I've explained, the judge asked the wrong question, and they're not, again, in relation to the 2024 sons, took the wrong comparison by looking at the position in relation to the contractual maturity date rather than the position in the relevant alternative. So we submit that there isn't any proper justification for giving the security to the convertible notes either. I thought my was about to say something.
Sorry, I am going to ask you a question.
Yes, yeah.
Just to go back for a minute, but I was finished.
No, I finished.
Finished the answer. Right. Okay. Sorry, maybe I've missed this, but when we were looking through 306,
yes,
and the justification that the judge gave, the answers he gave, we obviously looked at 306.2. Did we look at 306.3?
Well, I looked at that. I looked at that earlier when we were dealing with ground 3, because
Well,
yeah.
Okay, but can we just unpick it a little bit for
Yeah.
me, please? And apologies if I'm going back over old ground. But Ms. Smith's primary submission was that this was unfair because it involved a departure from pari passu principle. Okay, get that.
Yeah.
He says, but for the reasons which I've given, I don't consider the plan to involve a departure from the pari passu principle. Now, I think that is just a lead-in sentence to the next two.
Well, that's exactly. Well, that was the sort of debate
a bit
we
of
were
a debate
having.
we had
Yes,
yesterday. But
exactly.
let's assume for a minute
Yeah.
it's not a freestanding
Yes.
point. His two reasons for saying it's not a departure for the pari passu principle would be, first, if the plan succeeds, the maturity dates will remain unchanged and the plan creditors will be paid in full. That's the point which we debated a little bit yesterday, where your essential point is, but there was a big risk,
Yeah.
or at least not big, but there was a material risk that wouldn't be the case.
Yes.
And this is a case you say is all about risk, and the pari passu principle is designed to cater for risk.
Can I just make the point? I mean, will be paid in full is clearly erroneous by reference to his own findings. Because I mean, he never anywhere else puts it higher than likely.
Well, no, he says if the plan succeeds.
Yes.
He's correct. If the plan
Well, it's
succeeds,
conditional.
you
Yes,
will
I
be
see what
paid
he's
in
saying.
full.
Yeah.
Your point is, but if is a big if.
Exactly. It's a conditional.
Sorry,
Yes.
there's somebody light.
Yes.
Um,
Yes, your lordship's right. Exactly. So it's contingent on the hypothesis that the plan succeeds.
right.
Yes.
So that's the point. It's the if. But then he goes, if the plan fails and the group goes into default. And so this, in other words, is looking at the risk you say, which is the objectionable bit, eventually, actually happening.
Yes.
He says, then pari passu principle, or then the pari passu principle should be respected.
Yes.
And he doesn't say why. Come back to that in a minute. And then he says, on either assumption, the plan creditors will be no worse off than they would be in insolvency proceedings. I think that's just a bad wording.
Yeah.
In the sense that he can't mean that satisfaction of condition A is an answer to the
Yes.
discretion test. But I think what he's basically saying is, either way, you're going to get paid either in full or pari passu.
Yes.
So, stop whinging.
Yeah.
I'm interested in the penultimate sentence.
Yes.
Is that a reference back to the arguments about acceleration?
The alternative case.
Yes, I think
case,
I'd read that as a reference to the alternative enforcement scenario, the Luxembourg enforcement scenario.
Right.
And I'm going to come to that, but he's wrong to
Okay,
say.
okay, well, as long as you do, because
Yes.
at the moment I don't think we've really, unless I've
No.
missed it somewhere, that's, I think, a major part of the judge's reasoning, which is that even if the plan doesn't work, such that the risk that pari passu is designed to, or would cater for,
Yes.
you will end up in a pari passu position.
Yes, and exactly, and we say he's simply wrong about that because that's not the way in which the alternative enforcement scenario would work.
Right. You are going to come.
Yeah, I'm going to come to that. Yes.
Okay.
And I'm afraid I do have to deal with the Luxembourg enforcement scenario. Okay. Deal with that as a topic. It's
Well, as long as you're going to
it's a
deal with
little
it,
bit.
because otherwise, I think it's a.
It also slightly sort of posits sort of two binary alternatives. Either the plan succeeds or the
Yeah.
plan fails. Whereas the two alternatives you were presented with was either the BCG report or Ms. Rickleton's analysis.
Yes.
Those aren't the only possible outcomes. There's a whole range in between, which he accepts at one point. He says
He does, and
there's
that's
a
like-
spectrum.
That's exactly our point in a way. Actually. The ones he looks at are two particular points on the spectrum, but there's a whole number of other variables.
And you could end up with the plan almost succeeding,
Yeah.
but missing just by £500 million,
Yes.
and you'd be out of the money.
So that, I mean, your lordship's right. I mean, that €400 million headroom is actually a tiny amount in percentage terms. It's
300 million.
300 million, even less. It's about 4%. So you only need to be
4% of what?
of 4% of the total gross proceeds estimated. So the
Really? I thought the total gross estimated proceeds were 7 billion odd.
it is.
Well, 300 is not 3%, it's 7 billion. Mr. King Smith.
Yeah. Well, let me check. I was told it was about. So, yeah. Well, let me check. I mean, we'll check the percentage, but the percentage is the 300 million by reference to the estimated gross proceeds. So it's the 309 million over whatever that figure I showed you yesterday from the FTI report of around 7 billion odd. But my point is simply that is a pretty small amount you have to be out by in order for them not to be paid in full. So I mean, it supports exactly the point your lordship's making. Now, I mean, that I think deals with the question of security, and as I say, I'll come to the alternative enforcements now. On the new money, I mean, I'm not intending to say much more about that. It was a departure from pari passu because it obviously involves the incurrence of further priority secured debt that wouldn't have been there in the relevant alternative. In terms of the prejudice caused to 2029 sons, as I indicated yesterday, I accept that this is in substance part of the different maturities point, because the prejudice caused by that is the fact that we are at the back of the queue. If everyone had been treated pari passu, but the new money had gone in ahead of everyone equally, then one wouldn't have had the mischief. So it is linked.
Yeah, I mean, somebody might have come along and said, I mean, this is an illustration of a point which we were debating yesterday. If you weren't at the back of the queue, as you put it, and somebody had come along from a dissenting class and said, the new money is on outrageous terms.
Yeah.
People are just fleecing this company under the guise of a restructuring plan. It's totally outrageous. If, in fact, the other classes of creditors who, on this issue, would be in the same position had said as a commercial matter, well, okay, these are large amounts of money, but we think it's okay, then the court might say, well, that's a good illustration of adopting the same sort of approach that you apply on a scheme.
Yes.
Of saying, well, in commercial matters, creditors are their own best judges.
Yeah.
Who are we as judges to sit in judgment on whether a new money provider gets paid 5%, 10%, 15%, or whatever. In that respect, if everybody was the same. So that's why it's really, you say, in truth, just another facet of your point that you shouldn't be the most affected by the new money being added ahead of you.
Yes.
Yeah. Okay.
Now, I'm told the percentages, just to go back to that question, is 4%. It's 300 million over 7.16 billion, which is circa 4%.
Yeah.
So a reduction in the proceeds by only 4% will be felt by the 2029 sons.
Thank you.
Okay.
So, I mean, I'm sorry, my lord. I should say, I agree with the way your lordship put it.
Well, I was sort of just thinking out loud, as it were, but that's I think we did discuss that yesterday.
We did. Just on the Newman, just to complete, I said I'd come back yesterday on the point we made in paragraph 40, sub 2 of our skeleton, about the additional interest of 201 million euros payable. It's correct that broadly that would be paid on a pay-as-you-go basis. I mean, it's a little more complicated than that. But the point we were making was that 201 million would all rank ahead of the payment of principal on the 2029 sons. So that 201 million is additional interest. It's the interest hike under the plan. Part of it would go to us, most of it wouldn't, but all of it would rank ahead of the repayment of our principal. So that was the point we were making.
But if you had been harmonised under the plan in terms of quotes maturity dates,
Yes.
then
Wouldn't matter then.
It wouldn't matter. So again, that's just another facet.
Oh, it is, yes.
Yeah. It's not a separate point.
It's not. No, I'm just coming back. So I think I said I'd come back on that point. Then finally, on pari passu is the question of the allocation of the equity. And we say another unusual and objectionable feature of the plan is that it allows the existing shareholders in the group to retain most of the equity, 77.5%. And that's notwithstanding that it's common ground that's in the relevant alternative to the plan the shareholders would be entirely out of the money. They wouldn't receive anything at all, and they're not contributing anything under the plan that might have justified their retention of equity. In contrast to cases like Virgin Active and House, where the existing shareholders were permitted to retain their equity, but they contributed new financing to the restructured group.
But the critical difference with Virgin Active is that a group of creditors were being asked to take a haircut. I mean, nobody's suggesting you will be paid. I mean, the argument you got into with my lord and myself yesterday on this is that if the plan fails, you say it unjustifiably affects you because you're at the back of the queue. You bear the biggest risk of the plan failing.
Yes.
But in a sense, in that eventuality, the shareholders will be even further behind you.
Correct.
So what?
Yes.
You're in a sense not actually affected. It's not an extra point for you because you're already making your case on the proposition that you are at the back of the creditor queue.
Yes.
On the other hand, if you are paid in full, because as the judge said, that's a justification, he said, for the pari passu principle not making a sufficient difference to justify refusing to sanction the plan. If you're paid in full, you're out. And so the fact that shareholders then are allowed to stay, what's your problem?
Because it's not a point founded on prejudice. It's a point founded on the fact that the alternative to this plan is an insolvency, in which case value would break within the debt, the unsecured debt that we are part of, and the shareholders would receive nothing. Therefore,
nor would you. You wouldn't receive anything by way of equity either.
No, not by way of equity, but the value would break in the debt.
There wouldn't be any equity.
There wouldn't. The equity would receive nothing. So the existing shareholders are completely out of the money. The value breaks in the unsecured debt. Therefore, on the authorities, the unsecured creditors are the economic owners of the business. Now, as the economic owners of the business, the unsecured creditors are entitled to all of the restructuring surplus, or to decide where it goes. Part of the restructuring surplus includes the equity surplus that might be realised if the plan is effective, and therefore that surplus ought to belong to the in-the-money creditors who are the unsecured creditors. And that's, it goes back to T Corp. If I'm a little pressed for time, but I just want to look at Virgin Active, because my lord set out much of the learning that underpins this submission, and it's based on the question of who are the economic owners, who therefore are entitled to the surplus, whatever it is.
But is it right, Ms. Smith? If there was an equalisation of the maturity dates, which is what you primarily contend for, there'd still be a surplus for the shareholders if the plan succeeded, wouldn't there?
Yes, and we say that surplus ought to go to all of the unsecured creditors, the son holders equally. It's not. Why should the shareholders get anything?
But what do you mean by go to?
They get the equity in the restructured group.
What, on top of what's contractually due to them?
Yes, because they are the economic owners of this business. So,
okay, I have to say I am struggling with this proposition, and I appreciate you base it upon saying that they are, quotes, the economic owners of the group, but in law they're not.
Well,
and the extent of your interest is only to be paid 100% of your debt plus interest.
in my submission, that's not right, where you're dealing with an insolvent group. The economic owners of the group are the in-the-money creditors.
Well, you say the economic owners. What you're saying is the creditors who are at risk on that hypothesis of not being paid in full, i.e. where the value breaks.
Yeah.
You say can decide as between themselves how the value of the group should be allocated. But isn't the essential premise for that is that there is a shortfall? If you're saying that because the group is insolvent, they can actually appropriate to themselves the shares in the group as part of a restructuring, and therefore they can, by some means, deprive the shareholders of the shares.
Yes.
That's a more
Well,
far-reaching proposition, isn't it?
well, in my submission, not, because what matters is there is a shortfall in the relevant alternative. So the relevant alternative to the plan is a liquidation. In the liquidation, the shareholders won't receive anything. The value will break in the unsecured debt.
Okay, but let's retreat a little bit. Before we did restructuring plans, the way people used to do this was to say, here's a group where the value breaks in the unsecured.
Yes.
We're going to restructure it by putting it into a formal insolvency, and the entire business and assets will be transferred to a new co.
Yes.
And the new co will be owned by the creditors.
The in-the-money creditors.
The in-the-money creditors.
Yes.
Yeah.
So that's T Corp.
Yeah.
Yes.
And the basis for saying that was because if you were sure that the group was insolvent,
Yes.
shareholders had no interest in the business.
Correct. And then, but the critical question is, you work out that by reference to what happens absent the restructuring. So
Yes.
you effectively ask yourself, well, what happened? If I don't do this restructuring, what happens? You're going to go into administration. In the administration, shareholders won't get anything. The value is going to break, say, in the unsecured debt. Therefore, what I'm going to do is do a scheme under which the business is going to be transferred to a new entity owned by the in-the-money creditors. And you determine whether they're in the money or not by what would happen absent the scheme. And then the in-the-money creditors own the entirety of that enterprise going forwards. And that's, I mean, that in my submission, that is the established approach from T Corp, and then all the cases from that went forwards.
But it's more controversial if there is a okay. I mean, I've only ever seen it done in circumstances where. No, okay. You better take us to it, because I'm struggling with this proposition where there is a possibility of value.
But I don't. I mean,
going to shareholders.
let me put the point this way. I mean, if your lordship's proposition is right, then the shareholders would be entitled to retain the equity in circumstances where the alternative to the scheme is clearly insolvency, in which the shareholders are out of the money. But nonetheless, they'd be entitled to retain the equity just because there was a possibility that the creditors might be paid in full under the plan. And that in my submission, does not make sense and doesn't reflect the way in which this issue is analysed in all of the cases that have followed T Corp forwards. I mean, I'm slightly conscious of the time, but I mean, let me. Can I give you the references? I mean, what we principally rely on.
I mean, if you're right, I mean, this is a fairly major point.
It is a major point. It is.
No,
I mean,
I'm not just
and the
trying
judge
to
was
disguise
highly
it.
troubled by it, and he, I think, saw the force in what we were saying, as I'll show you in a moment, but then tried to see his way through it in a way that we say was unsatisfactory. But no, it is a major point, a very major point.
I mean, the issue of the respective rights and interests of creditors and shareholders in these types of plans is a really, really critical sort of area in a number of cases.
It is. I mean, can I just show you what, I'll just show you the passages we rely on in Virgin Active, because we principally found ourselves on what was explained there as the law. I mean, it helpfully pulls together the principles in our submission. I'll just give your lordship the passages, because I'm probably not going to be able to read them all out, but it's paragraph 238, page 912. This is authorities bundle 2 for your lordships, behind divider 28. paragraph 238, your lordship describes, in effect, the conventional position which we've just been discussing from cases like T-Corp. In each of those cases, the essence of the proposal was that the business and assets of the failed company should be transferred to a new company to be owned by those who would have been entitled to a share in the distribution of the proceeds of sale of those assets in a formal insolvency. So those persons who are entitled to receive the business are those who would have been entitled to share in the distribution in the insolvency. So in other words, the in-the-money creditors. By this route, the creditors and shareholders who would be out of the money in the formal insolvency would be left behind in the shell of the old company, and the benefits of future trading would be enjoyed by those who would be in the money in the formal insolvency. We respectfully agree with that. And then you get the same from Mr. Justice Mann, in effect, in the Bluebrook case, where he applied those principles in that case. 240, your lordship refers to Noble Group as an illustration of that principle. Your lordship in that case held that the shareholders were entitled, or there was a justification for the shareholders being entitled to part of the equity, notwithstanding that they were out of the money. And then, if we just go on, paragraph 259. So 259. As we looked at this before, the key principle therefore appears to be that both under Part 26 and Part 26A plans, it's for the company and the creditors who are in the money to decide, as a dissenting class that is out of the money, how the value and business of the assets of the company should be divided. So it's the entitlement and right of the in the money creditors. And then your lordship posed the question whether it's possible for out of the money creditors or shareholders to be given something nonetheless, even though they're out of the money. And the answer to that is, well, it's conceptually possible. And in 263, your lordship, as an example of that, goes back to Noble Group, and you, based on the facts of that case, found that there was a justification for giving equity to the shareholders even though they were out of the money. And the reasons for that were essentially given against letter F on page 124. And then if we go on, 266, the position as it happened in Virgin Active was that those creditors who were complaining in this case were in fact out of the money. So the AHG landlords, who were the dissenters, your lordship found that they were out of the money, and therefore in 266, your lordship essentially was able to deal with the point simply by saying, well, because they're out of the money, their objections carry no weight. And that's again, we respectfully submit, clearly right. But your lordship did go on then in 267 to ask the question, well, what are the sort of factors one would have needed to look at if this had been a situation where those creditors were in the money? In other words, those who were complaining that the equity was being given away at their expense were in the money. And your lordship goes through that exercise in 267 onwards. And essentially, your lordship identifies 3 points. The first, in 268, you say, well, on the facts of Virgin Active, those most affected by the shareholders retaining the equity were the secured creditors, and they seemed content with that. Well, that, if you apply that point to our case, I mean, we are in the analogous position to the secured creditors, because we're the in-the-money creditors in this case, and we're the ones who are affected by the equity being given to the shareholders and not to us. And then the second reason your lordship gives is essentially paragraph 270. And there was a specific point about the course of the negotiations in Virgin Active, which was specific to the facts of that case. And then 278, the third reason your lordship identified as to why the shareholders might be entitled to retain the equity, notwithstanding they were out of the money, was because they were putting in new money themselves. So the retention of the equity was in essence a quid pro quo for the introduction of the new money. And then your lordship, there's a very useful, if I may say so, analysis of in comparison with the position in Chapter 11 bankruptcy proceedings, looking at the sort of circumstances in which shareholders who are out of the money may nonetheless be entitled to retain equity. And your lordship essentially identifies two circumstances. One is if the shareholders put in new money, so they're giving a quid pro quo for their retention of the equity, or it's in effect gifted to them by creditors who are in the money. And then your lordship comes out at 300. On the facts of that case, your lordship says, well, even if the dissenting creditors have been out of the money because of those considerations, including the fact the shareholders are putting in new money, I don't conclude that the retention of the equity by the shareholders should have led me to exercise my discretion.
Okay, I'm just trying to put this into context. I mean, okay, so my memory's been refreshed. I'm not sure I'm happy about that, but anyway, I've seen that at Virgin Active. But if you had harmonised and maturity dates with the other Sun note holders, and there was no security granted to the 2024 Suns, i.e. your two other points.
Yes.
Would you still be entitled to complain that this was a freestanding point?
Yes.
In circumstances where, see, in Virgin Active, as I recall it, what was basically being said by the opponents was, look, we are being differentially required to compromise our claims as landlords more than some other creditors in circumstances where the existing shareholders are allowed to retain their equity. And Virgin was a case, therefore, where there was both a differential haircut and a retention of equity in an ongoing group.
Yes.
In an ongoing business. In our current case, if your other 2 points were remedied on pari passu distribution, why would you independently be entitled to complain of the fact that the equity is just being allowed to retain in circumstances where you would be in the same position as all the other Sun note holders?
Yes.
And it's picking up a point which we debated at some length yesterday. All the other Sun note holders who, on this hypothesis, would be in the same position vis-a-vis this question as you, would be entitled to say, look, that's just the commercial deal. We're rational people and we think it's appropriate. Does it add any more to your other 2 points? Why can you complain of it independently of your other points on pari passu? Because
if I may say, I think it must be your lordship's running 2 points together there. I mean, the first point is it's for the in-the-money creditors to either receive the restructuring surplus or to decide how it's distributed. So if we were all treated together, pari passu, under the plan, and no one got prior security, then it's a question for the Sun holders as a class either to receive the equity or to decide what happens to it. In my submission, that's the position. Now, I think it's a separate point for your lordship to say, well, actually, if most of the Sun holders had nonetheless voted in favour of the plan on that hypothesis, then under the plan the shareholders receive the equity, then that's okay because that's what they voted for. Well, I mean, that might be right, but that's a separate point because you're effectively saying, well, they have, in essence, decided to give the equity to the shareholders for whatever reason. But there are two different points in our submission.
I mean, that, in a sense, it's a commercial judgment, isn't it? Just as to whether the plan is commercially acceptable.
Well,
if all the other pari passu points are resolved in your favour, I'm struggling at the moment to understand why the collective decision of the Sun note holders on this plan.
Well, that goes to what they were told in the explanatory statement, doesn't it? Which is the final point I want to make on this topic, which is the explanatory statement, contrary to what has been said in the footage, didn't contain any explanation of why the equity was going to the shareholders, and indeed barely even made clear that the equity was going to the shareholders. So on the facts of this case, in my submission, you can't possibly rely on the votes of the Sons as somehow deeming or accepting that divergence of the equity to the shareholders, because it was nowhere explained to them that's what they were doing and what the alternative was, and they could keep that for themselves. But I do. Those are the key points we rely on from Virgin.
So does it? So if the other points were resolved, if the plan had taken the form which resolved your other objections to it,
yes,
your objection to this point, your freestanding. I'm trying to identify your freestanding objection. I do think I understand it now. Your freestanding objection to this is actually not one of principle. It's not that it's impossible to do this.
Oh, yeah.
It's impossible for creditors to agree to shareholders retaining the equity. It's that that wasn't properly explained to them in the X-plan.
Yes, I don't say, absolutely, just to be clear, I don't say creditors can't agree that the equity should go to the shareholders. Plainly, they can agree that. And that's one of the two circumstances in which it's permissible for out-of-the-money shareholders to retain the equity. One is it's in effect gifted to them by the in-the-money creditors who say, yes, we're fine with that.
That's Virgin.
Well, not really Virgin, because, well, partly Virgin, but also there was new money in Virgin. So Virgin sort of ticked both boxes, as it were. But yes, they can agree to that, but you need a properly informed decision for them to do that. And that the facts of this case don't come close to hitting that.
Yeah, well, in fact, you've said on a number of occasions that, I mean, the explanatory statement, the adequacy or otherwise of the explanatory statement actually goes to, in a sense, underpins. I'm not sure is it a separate ground of appeal?
No, it's not a separate ground of appeal, but it comes in when you're looking at the question of the weight to be given to the vote.
Yeah.
Yeah. Can I just want to move on a bit, if I may, just to deal with, just show you, your lordships, what the judge said on this point. It's paragraph 324, page 909 of the judgment. And I mean, for once, we're in agreement with the judge in paragraph 324, because we submit he's got it right on this point in identifying what the mischief is. He says this is the point on which I have had the greatest concern about approving the plan. I can see no obvious reason why the shareholders who provided no support for the plan and no additional funding should get the upside if the plan succeeds. Well, we agree. The plan creditors, rather than shareholders, take the risk that the plan will fail. Well, that's also correct. I therefore accept Mr. Smith's submission that there's no compelling logic in Mr. Bayfield's position that if the plan creditors are paid in full, the shareholders should retain their equity. And then we get this sort of curious, in our submission, analysis in paragraph 326. And the logic of these points appears to be that the new money providers could have negotiated for more of the equity. So rather than negotiating for 22.5%, he says they could have negotiated for more. But in our submission, that isn't an answer, because the fact that the new money providers were content only to receive 22.5% of the equity doesn't mean that the out-of-the-money shareholders get the remainder rather than the in-the-money plan creditors. It just doesn't deal with the point. I mean, the new money providers have in effect left 77.5% of the equity on the table.
So your analysis is because the creditors are asked to carry the risk of the plan failing, they should get the upside if it succeeds.
That's part of the reasoning. It's not the sole reasoning, because I rely on the economic ownership question as well. But we do also rely on that as this additional point, the point the judge makes in the third sentence. And so on this point, the judge has absolutely correctly identified the issue in 324, but it's just that 326 doesn't begin to answer it. Now, the other point on this is that contrary to the authorities, the explanatory statement did not explain why the shareholders were to retain the equity, and that's just an omission. I can't show you anything in the explanatory statement to make that good, because it just isn't there. And indeed, the explanatory statement didn't even make clear that the shareholders were to retain the equity and not get the surplus. You could possibly work that out from looking at the BCG report, I think. But even on that, it wasn't particularly clear. And that is contrary to what has been expressly said in the first instance cases. And I'm sorry to keep turning up my Lord's cases, but I mean, my Lord has obviously.
Right, as long as nobody takes anything I say as gospel in this court, that's fine.
If it's tab 22 of volume 2 of the authorities Sunbird, and it's just the only paragraph we need to look at here is paragraph 62.
Sorry, which tab? Again.
So tab 22, paragraph 62, page 690. So, I mean, you're making the point, if I may say so correctly, that where the existing shareholders who, by definition, in other words, in a case where insolvency is the relevant alternative, would receive nothing, are being permitted to retain a material stake in the restructured company. In such a case, it's likely to be essential for the scheme company to provide a detailed statement of the underlying assumptions and valuation methodology that's said to justify such an outcome, so that creditors can reasonably assess objectively whether the allocation of losses and division of benefits among stakeholders is appropriate and fair. And I mean, we respectfully submit that that is self-evidently right, and it was something that was not done here. And
I mean, this is most. I think I refer to Virgin Atlantic. I mean, the background to this is this sort of very simple proposition that if, for example, you just take a standard creditor scheme where you are scheming the finance creditors, but you're leaving out of the scheme altogether, for example, trade creditors or employees, who in an insolvency would be just unsecured creditors like finance creditors. You need to explain to the finance creditors who are being asked to take a haircut that there are some other creditors who are not.
Yes.
And explain to them why that is.
Yes.
And then, but then the decision as to whether that's appropriate is the commercial one for the finance creditors in that case. You know, do we think that's appropriate or not? And if the majority by the statutory majority say yes, all other things being equal, the court will just say, well, that's their commercial decision.
Yes, exactly.
But the essential point is they need to have had it drawn to their attention so that they can, at least the court has confidence that the decision has at least taken that into account. Exactly
right, and that wasn't done here, and that's why you can't treat this as a case where the interested creditors have in effect agreed to give the equity to the shareholders. This was just not on their radar at all.
I mean, along similar lines, have we actually seen, I don't think I have, so let me just say, I don't think I have seen what was said in the explanatory statement about any of the points that you are
Well, nothing was
debating.
said about,
I mean,
nothing was said on this point. I can't show you anything because I mean, I was going to ask your lordship whether it would be helpful to have a copy of the explanatory statement in full. The reason it wasn't in the bundle in full was I think we were under quite a severe page limit as to what we could put in the bundle. I mean, if it would be of assistance to have the explanatory statement.
You're saying that all it'll do is kill a few more trees because there's nothing there on any of the points.
On this point, there's nothing there. On the point your lordship asked me yesterday about, does it say anything about the reason why pari passu isn't being observed, I've identified the meagre amount which there is on that, which I was going to hand up and show your lordship in due course. But on this point, there isn't anything.
Well, I mean, obviously Mr. Bayfield can take us to anything that he wants to rely upon, but I think for myself, I would certainly not encourage the killing of trees just for the sake of it, but I would like to see anything which you consider could be material to these points.
Yes, I'll nothing on this point, so it's a nil return. On the point I'm coming to, I've got the pages which I will show you. So, my lord, that deals with the equity. Now, before I depart from ground 4, I was going to deal with the point your lordship identified a moment ago, which is what the judge said about pari passu distribution in the default scenario by reference to the alternative enforcement position. Now, we deal with this in our skeleton argument, paragraph 28, page 950, and if I ask your lordship to turn that up. And we deal with it by reference to paragraph 299 of the judgment, but he's essentially making the same point in 299 as in the subparagraph 302 sub 3, which we were looking at. And in our submission, the judge was wrong because the alternative case, the alternative enforcement scenario, it also involved a departure from the pari passu principle for at least 3 reasons. The first was that the 2024 sums and also the convertible notes would in any event be paid in priority because of the security given to them under the plan and the restructuring. Paragraph 28.2. So he was simply wrong because he ignored the fact that the security, the priority security was given to the 2024 sums and the CNs, and that on any view they would get paid in priority because of that security right. And it appears he's just overlooked that point. The second point is paragraph 28 sub 3, which is that in any case, under the enforcement scenario, assets were going to be disposed of in order to repay the new money lenders before any enforcement took place. So there was going to be a process of realising assets in any event, at least to repay the new money lenders. But then thirdly, is the point we make in subparagraphs 4 and 5, and this is perhaps the most important point, which is that the judge's point assumes that the alternative enforcement scenario would occur prior to the repayment of the early dated sums. So he's assumed that if there was this enforcement scenario, it would occur prior to the date on which any of the sums fell for repayment. But there simply isn't any basis for that assumption, because it's at least equally possible that the enforcement scenario would occur after the date of payment of some of the sums. And that's because the enforcement scenario is in effect triggered by a breach of a loan-to-value covenant, which is breached when the value of property prices falls below a certain percentage of the debt. So the moment in time at which it triggers depends entirely what happens to property prices. So the moment in time at which the default enforcement scenario happens depends entirely on what happens to property prices. I mean, if the property prices are fine until 2027 and then drop in 2027, then the enforcement scenario will take place at that point. But all of the sums that have matured prior to that will already have been repaid. And he's just again overlooked that point. It's an important point. So, I mean, that point, for those reasons, doesn't provide any answer to this.
What was the loan to value covenant? Was it 85% cover?
I think it was 85. I think your lordship's right. Yes, I think it was 85%. So, well, that's ground 4.
Again, so in other words, again, just to so I've understood it, you're identifying this as a risk which the judge didn't, you say, appreciate.
Well, there's a point the judge didn't appreciate because it means he said that the alternative enforcement scenario means you're nonetheless treated pari passu. That's wrong because it depends at the moment in time at which the...
Yeah, but that's a risk. Sorry, that's...
Well, if you put it, yes, at risk. Well, he didn't take that point into account.
Even if values remained entirely level, you might find that the covenant was not breached at the outset. When you sell a property, you pay 100% of the value of that property to the then loans, and you might find the remaining properties. You breach the 85% even if you haven't, even if none of the values have changed at all, because you've used all the proceeds of your first sale to pay off.
Exactly right, and we obviously have a similar concern to that, which is one of the things that may happen is the good properties get sold first, and leaving you with the less good properties.
Yes, that's a slightly different point.
It is a slightly different point, but it goes to the dynamics of this. It's very fluid. I mean, the point in time at which the LTV covenant might be triggered so as to lead to enforcement action is probably impossible to predict.
In a sense, it's more likely to be triggered later than earlier, because if you sell, when you've got good properties on the whole, it's presumably a percentage, it's a proportionate covenant.
It is, it's 85%.
So
the loan.
Your point is if you get rid of all the quotes good properties, you're left with the ones that are more difficult to realise, the value of which is more in doubt. And so it's inherently more likely, you say, that the covenant would then be breached later rather than earlier. Yeah, okay.
And just a final point on this. I mean, this alternative enforcement scenario is nowhere referred to in the explanatory statement, not mentioned. It appeared for the first time in the company's evidence in reply, a matter of a few days before the contested sanction hearing. So creditors who voted on the plan that were completely oblivious to this alternative enforcement scenario on which the company thought to place much reliance in front of the judge. So that's ground 4. Ground 5 is, we say the judge erred because he put too much weight onto the majority vote. We've, I think, covered a lot of ground on this. The point I made yesterday is that if the court thinks objectively the plan is unfair because it departs from pari passu in a way that has no proper justification, then it's not possible to override that simply because a simple majority within the dissenting class may have voted in favour. That vote doesn't make an unfair plan a fair one. And as I submitted yesterday, if the position was otherwise, then you're in effect reducing the 75% majority requirement. Now, the way we read the judgment is that the judge did in fact attach a lot of weight to the majority vote and treated that as a decisive consideration in his analysis. And the relevant paragraphs are paragraph 302 sub 5, 302 sub 9, paragraph 344 of the judgment. And it's also just interesting to see what he said on the permission to appeal hearing, which is in supplemental bundle behind divider 12.
I mean, it is the. I mean, you say it's ultimately. Sorry, the word is ultimately. It's all encapsulated in 302 sub 9. I think you.
Yes,
that's the one you say. It just gives the game away from your perspective.
And also I think 344 actually is quite telling, because when you get to his final word at the very end of the judgment, look at the point which is singled out for mention in the conclusion.
By the majority of players in all classes. Okay.
Well, I know it goes even broader than that.
Yeah.
But I just wanted to show you, just whilst we're here, it's also relevant for you to see what he says in the on the transcript of permission to appeal application hearing, which is in divider 12, page 21 of the transcript. And perhaps you pick it up on the very first sentence, very last line of page 20 over the page, because I was referring the judge to paragraph 302 sub 9. And I said, as also 302.9, if you look at what your lordship relied on, it's essentially the satisfaction of the no worse off test and the vote. That raises the question of the weight you attach to those factors. In our submission, one would attach relatively little weight to those factors when it comes to the question of the fair distribution of benefits. And then there's a little bit of a diversion, but he then says, lines 17 to 19, all I'm saying, it was an exercise of discretion where ultimately those two factors tip the balance. So that, and he's quite clearly referring to satisfaction of condition A and the majority vote in the 2029 Suns. Now, the other reasons why the vote isn't conclusive is, as we say in paragraph 48 of the skeleton argument, many of the 2029 Sun holders also had holdings in the earlier dated Suns. And in fact, 59% of the 2029 Suns who voted in favour had cross holdings in the earlier Suns.
So do you mean 59% of those who voted in favour, or
59%
of the whole?
I mean 59% of those who voted in favour.
So 59% of the
62 or whatever. 62% of voted in favour, 59% of that 62 had cross holdings.
What do you mean? Just over 30% of the whole, 30 or something percent whole. Sorry, it's what you just said is ambiguous. Do you mean of the 62? Do you mean 59 of the 62?
Yes.
Leaving 3, or do you mean 59 multiplied by 62 equals something?
I mean, if you take that group of 62%, 59% of that group had cross holdings. Does that make sense?
You've still left the ambiguity my lord referred to. Do you mean that 3% of the 62 didn't have cross holdings, or do you mean that 41% of the 62 didn't have cross
The
holdings?
latter.
Right.
The latter. The latter.
Can we look at the raw material, because I didn't find it at all easy to understand what this was telling us.
Well, the raw material, I think, is difficult because it's obviously hugely anonymised. So I don't think you can work out from.
If necessary, I've said this many times before. If necessary, it shouldn't be anonymised. We're in open court here. I know people have commercial interests, but they're asking the court to make a significant commercial decision.
Yes.
And, it can be no obstacle to the court understanding the case that certain people want their names anonymised.
Well, we have no objection to that. I think the information is undoubtedly within the planned company's possession and control.
We can try and understand it without actually ascribing names, for the simple reason that somebody has helpfully ascribed numbers to the creditors as I see it, and provided we can work our way through it. But if it becomes necessary at some point to know the actual identities, then it can't ever be an objection to the court understanding the case that somebody doesn't want their name to be associated with their vote.
We have no objection to that, and if the planned company is able to provide unanonymised data, we would welcome that.
But it can be done. It may cause all sorts of other problems about confidentiality and having to give undertakings to use the information for the purpose of the litigation. But we probably can get to the bottom of it if we know by reference to the numbers who, for example, belongs to your group, who belongs to the SteerCo, and how you read across. I think we probably can get it by numbers, but
We probably can. I mean,
we need a little bit
you
of
could have a
digest.
sort of, you could have almost a sort of index that identified which holders were in which grouping. But I mean, we don't have that at the moment. I think we would certainly be able to do it for ourselves. I'm not sure we can do it. I'm not sure we're in a position to do it for the SteerCo. I suspect the company is. But my lord, and the other point is, it's really the company that's relying on the majority vote. I mean, we, from our perspective, say it carries relatively little weight, and also you have to treat it with caution. Firstly, because of the cross-holdings point, which I've already made. A majority of those 2029 sons who voted in favour had cross-holdings in the earlier dated sons. Now, the planned company tries to deal with that point, because if you go to its skeleton argument, paragraph 53.2, it says, and this is page 994 of Cold Bundle 2, subparagraph 2, it refers to what it calls the pure holders of the 2029 notes. So, in other words, the holders who don't have cross-holdings. And it says, of the pure holders, the great majority of them voted in favour of the plan. Well, that, in our submission, needs to be treated with quite a lot of care, because it doesn't deal with the value of the holdings, it just deals with the number. Now, by value, we work out that those 35 held only 23.7 million euros of the 800 million debt, so about 3% by value. Of the 28 who voted in favour, just to give your Lordship a flavour, 8 of them had holdings of only 100,000 euros. In other words, the minimum denomination you could get. 15 had holdings of less than 500,000 euros. These are very, very small amounts. By way of comparison, my clients hold 235 million euros of the 2029 sums. And the obvious point we'd make is that if someone holds 100,000 euros of this, I mean, which would be a tiny holding for an institution, one might realistically wonder how much time it would spend considering this plan. Probably not very much in reality. Against that, we've got 235 million euros. We're very concerned about it. We've engaged with it. We've got our own advice, our own analysis, and we're the ones who oppose it vigorously, because we think it's fundamentally unfair to 2029s.
Does that mean that your clients have holdings in the other sons?
Yes, we do.
But despite that, you voted against the plan because what you see as the prejudice to your 2029 holding outweighs the advantages you get from being in the other.
Exactly, but also because we also hold, for example, 2027s, and we think the plan is actually pretty bad for 2027s also. And it's actually a very good plan for 2024s. If you're in the later dated notes, whether it's the 2027s or the 2029s, we think it's pretty bad. But certainly for the 2029s, it's being very bad.
So just looking at the data, so can we just look at the data then, just
Yeah.
to make sure we're actually in the right place? I mean,
So your Lordship's in the supplemental bundle.
I looked in the supplemental bundle starting at page 218.
That's correct. So these are the extracts from the. Yes, exactly. So this is the voting data.
And as I just to be clear, as I understand it, pages 218 through to page 223
Yes.
are the people who voted in favour of the plan.
I didn't get that. I think it goes through to 223B.
223A is the people who voted against.
That's against 223A, yes.
There's a tiny little word in the it's where,
Oh,
top,
yes,
top,
yes, I see.
top left-hand corner, yeah.
Thank you.
Yeah, exactly.
and so just so we do sort of just so we know.
So
how we read
218 is votes for. 223 A is votes against.
And so just looking at it very crudely, you say if you look down, and these are helpfully, I think, organised in terms of size of holdings.
Yes.
And your basic point amounts to this. If you look at 218, you can see there's quite a lot of black spread across the entire page.
Yes.
So in other words, you say the people with the biggest holdings who voted in favour held a lot of notes across the entire piece, including at the left-hand side the 2024 sums.
Yes.
When you, as you go through the pages of those voting in favour, you can actually see that the numbers of cross-holdings on the left-hand side of the page start to diminish.
Yes.
It's less black, to put it very blunt, crudely.
Yes.
When you go to the people who voted against, starting at 223A, the predominance of the holdings voting against are on the right-hand side of the page. In other words,
Yes, the black's moved across
the black has
page.
moved across,
Yes.
and you can see that people, without getting too subtle about it, that the holdings on the left-hand side of the page are relatively few and far between and in small amounts.
Yes.
So it shows that when you in fact look at it, the division of voting was
You can see where
why
people have
were
gone.
voting what
Yeah.
they were voting for, broadly speaking.
Yes.
You say. And you say that when you get to look at the number of pure holders, and you have to work through with a ruler to see who doesn't have holdings across anything other than the 2029 sums.
Yes.
There are some people, for example, I think the first pure holder you get to who voted in favour. You have to go back. I think is to be found.
Yeah, they tend to be the smaller ones, so it's almost easier to start at the other end.
I thought it was.
So if you go, an example is holder 271 and 272 on page 223. In fact, it is easier to find these by starting at the end because they tend to be the smaller.
This first one's holder 74.
Right, thank you. The first pure voter in favour
Yes.
is holder 74, okay, who held, as I see it, is it 0.7%
Yes.
of the face value of the 2029 sums.
Correct.
So that person holding 0.7% of the whole voted in favour.
Correct.
And then you go down, and your point is that a large number of people holding 0.1% or less, including the people just holding the bare minimum 100,000 who are actually said to hold 0.0.
Exactly. When you see those on 223 particularly. Yeah.
Right.
But I mean, why are we doing this detective exercise? I mean, we know what the voting figures are, and all right. So some people had holdings in more than one class, but I mean, one can't. I mean, I suppose your point is that's an additional reason for giving very little weight to the thing. But I mean, the real problem here is that the judge seems to have given inconsistent reasons. I mean, in one breath he says, well, he didn't ascribe any real weight to the voting figures, and
Yes.
in the next breath he seems to have said it was almost the decisive factor.
Yes, I mean exactly, quite. Because he actually he starts his judgment by saying that the vote, I treat the vote as not the decisive factor. He in fact says he thinks it's not an important or decisive factor, paragraph 66. And then you get to paragraph 344 at the other end of the judgment. And what's the one matter which is mentioned?
I mean, it does look as if that was what swung it, so to speak.
Yes. Well, that's how we read the judgment.
But I mean, your real point is that the fact that you had a majority, or even in your class, isn't sufficient to override the other objections.
Correct. That's our primary point.
As a matter of principle.
Exactly. But I just show you that, and the reason is just because the plan company does rely on it, so we point is just by way of caution. And the other point we would make as to why caution needs to be placed on the vote is the way in which the matter was presented to plan creditors in the explanatory statement. It was put to them on the basis that they would be paid in full under the plan, compared with a likely much lower return in a liquidation, which was the alternative to the plan. They were given the BCG report, which showed 100% return. There wasn't any sensitivity in the BCG report around that, showing possible alternative outcomes. But even more fundamentally, it was nowhere explained to plan creditors that the plan was diverting from the pari passu distribution, which would otherwise apply, that there was no good reason for this, and that the objectives of the plan could have been met equally by a plan which treated the sons all equally. And this, on this point, your lordship asked me, my Lord Justice Snowden asked me yesterday what there is in the explanatory statement, and the answer is it's fairly meagre, but for completeness, perhaps I could hand up what we identified. So there's three bits, one for each of their lordships. So, I mean, just to deal with these in turn, paragraph 6.47 is probably the closest one gets to the point being dealt with, which simply refers to a letter we'd sent where we said that the restructuring plan results in unequal treatment of pari passu creditors. And that was a letter of objection we'd written. And they refer to that and they say the AHG is yet to particularize its complaints in detail. Nevertheless, the group is confident that the issue of substitution is effective as a matter of German law, that the restructuring plan treats all classes of creditors fairly and leads to materially better recoveries for all creditors than the relevant alternative. And the issue of substitution and restructuring plan would be recognised by German courts. So that's pretty much the most one gets. If you look at the other provisions, 2.9 on the next page, page 48, is a table of amendments, summarising the amendments to the sons. If you turn over to the top of the table, it's quite interesting in our submission to note the way it was presented to plan creditors, which is that it was presented to them that they were retaining their existing contractual maturities. And of course that is a somewhat misleading impression where the relevant alternative is formal insolvency, in which all of them would, in effect, be in the same boat. And again, it sort of falls into the same trap the judge fell into, looking at the position outside of the formal insolvency, which is the actual relevant alternative. 210, you'll note, the plan company anticipates that if the restructuring plan is sanctioned and broader restructuring is implemented, each of the sons will be repaid in full when due. 3.21.
Sorry, I missed where you were reading from.
Oh, sorry, I was reading from paragraph 2.10, so just underneath the table.
Sorry.
Yeah. And then, just to complete this, 3.21 on page 64, we just draw that to your lordship's attention because it goes, I think, to the point my Lord Justice Snowden referred to yesterday, which is the reasons why the plan creditors were put in different classes. And you can see what they say. However, despite the equality of treatment, they say, amongst the sons, other than the 2024 sons, they seem to accept the 2024 sons aren't treated equally. In light of differences between the maturity dates and contractual interest rates of the different series of sons and the difference of opinion indicated by the results of the consent solicitation, the plan company considered it prudent that plan creditors be divided into 6 separate classes.
I mean, it'll be for Mr. Bayfield to explain what concept of prudence is being deployed there. my understanding from having a quick squint at the convening judgment of Sir Anthony Mann offline yesterday, I don't think it's in the bundle.
It's not.
Is that it was presented to him on the basis that a quote conservative approach was taken, which is consistent with that.
Yes.
Were you at the?
I was at the convening hearing. Yes.
I mean, is there any further light to be shed upon the analysis yesterday that I sort of proffered, that you put people into different classes because you can't put them in the same?
Well, they were put into different classes in that submission because they clearly had different rights coming out of the plan. And
yeah, the same rights going into the plan because the alternative comparator per hawk is the insolvency.
Correct.
So therefore, it must be recognised that they have sufficiently different rights coming out that you should put them in a separate plan. So
Correct.
A separate class. Sorry. So, but from recollection or from the skeleton arguments, is there any more you want to say?
No, I mean that's essentially it. So
okay, well,
it does reflect. I mean, the key point is it was reflective of a difference in rights under the plan, and that I think is sort of reflected really in what they say in 3.21, because the difference in maturity dates, in particular, is obviously a reason why you would have to put them into separate classes, and then they obviously accept 2024 sons go into a separate class, and that's presumably because of the security, the priority security given to the 2024 sons. And then just finally on this, the final point, just to draw to your attention, is page 71, 2.7. Just to note again, the way it was presented to the sons was that their maturity date would remain unchanged, which, as I say, is a somewhat misleading way of putting it, where the relevant alternative is an insolvency under which everyone will be pari passu and in effect have a presently accelerated due debt. So well, that's ground 5. Ground 6 is, we say, the judge placed too much reliance on the fact that condition A in 901G was satisfied. He said in paragraph 65 of the judgment, and this is page 780, at the top of 780, the last sentence of paragraph 65, there is no presumption in favour of sanction, even if the plan company satisfies both conditions A and B, which are jurisdictional requirements C virgin active. And that's where my lord had poured a little cold water, if I can put it that way, on the fair wind point that had arisen in one of the earlier cases. Now we respectfully agree with the statement of position articulated by the judge there, but again, it appears he didn't follow his own approach by the time you get many paragraphs further on in the judgment.
So sorry, I was just behind you because I was putting those pages away. Oh. Sorry, can you just for me give me the paragraph in the judgment you would?
I was just looking at paragraph 65, so page 780. It was the last sentence of paragraph 65 at the top of that page. Yeah. There is no presumption in favour of sanction, even if the plan company satisfies both conditions A and B, which are jurisdictional requirements C virgin active.
I thought Mr. Justice Trower had actually said something subsequent.
He had, yeah.
Which is slightly different from his sort of initial following wind.
He had
approach.
He essentially, I think it was ED&F Man. He said there's obviously no presumption or something like that. Now, I can give your lordship the reference if you want. Your lordship recollection is correct. And we agree with that as a statement of position. But again, the difficulty is that by the time you get many pages later on in the judgment and wade your way through to paragraph 306, where he's dealing here with the security question, page 902. He says at the final sentence of 306.1, I accept Mr. Bayfield's submission that the court should approach this question on the basis that condition A has been satisfied. Now, very difficult to understand what he means by that. I mean, in a sense, you always have to approach the question of discretion on the basis that condition A is satisfied, because that's one of the conditions to the jurisdiction arising. If you don't satisfy the condition, you don't have a discretion to exercise at all. And if that's what he's saying, well, that's just a statement of the obvious. But in fact, what he seems to be saying is that this is a matter that also goes to the exercise of his discretion. So he's treating the satisfaction of the condition going to jurisdiction also as being a matter that carries weight when it comes to his discretion. And I showed you earlier the reference from the transcript of the Permission to Appeal hearing, where he said that this was one of the two factors that tipped the balance. So it's obvious that he has, we would submit, treated this as a weighty factor in favour of the exercise of his discretion. And in our submission, that's wrong. And it's essentially wrong for the reasons that were explained in Virgin Active at tab 28 of the authorities bundle, paragraphs 223 to 224. And the reasons, I think, they're sort of self-explanatory. And the basic point is, well, condition A is simply something that has to be satisfied in order for the jurisdiction to arise. It doesn't mean you then don't go on and consider all of the relevant factors that are relevant to the exercise of discretion, or that you approach the exercise of discretion on the basis that there's some kind of presumption in favour of sanction. And most obviously, we submit that the fact that condition A has been satisfied can't be an answer to an obvious unfairness in the substantive terms of the plan. Put it another way, even in the scheme of arrangement context, if the baseline fairness test was met as per TNN, that wouldn't excuse an obvious unfairness or blot in the terms of the scheme. It's just something you need to get over as a preliminary point to even get into the stage of being able to ask the court to sanction the scheme. And overall, we submit that a fair reading of paragraphs 302 and 306, particularly when you look at what was said in the Permission to Appeal hearing and in the final paragraph of the judgment, is that the judge sanctioned the plan as a matter of discretion because condition A was satisfied. The assenting classes and 62% of the 29 sons had voted for it. It was not part of the court's role to consider whether an alternative, fairer arrangement was possible, and the honest, intelligent person test was met. And that approach was simply erroneous for the reasons I've explained. No, my lord, that deals with ground 6. Ground 7 and 8 I will have to deal with very briefly. Ground 7 is a different ground. It goes to the satisfaction of condition A itself. As I showed your lordships yesterday, if you go to 292 of the judgment, on page 895, the judge's conclusions in 292 on the satisfaction of the no worse off test depended on his conclusion on the plan company's alternative case, which involved the enforcement scenario, the alternative enforcement scenario. As I say, that didn't feature in the explanatory statement. It was put forward for the first time in the plan company's evidence in reply. If you go to paragraph 55 of our skeleton argument at page 959, we explain how it works, that scenario. I mean, it has to be said it's a rather complicated and contrived scenario that depends on two provisions of the amended sons. Firstly, what's called the LTV covenant, but also something that's called the release price mechanism. And essentially what the hypothesis was to say, well, once the amended sums come into force, there will be these two provisions in place. The release price mechanism, as it's called, will prevent any assets being disposed of, because effectively it restricts the ability to dispose of assets. And then at the moment in time when the LTV covenant came into force at the end of 2024, that covenant would apply from that moment in time onwards. And if that covenant was breached, there would then be an enforcement. And if there was an enforcement, there'd be a distribution to the creditors outstanding at that time, which would take place on a pari passu basis, it was said. So that's the essential logic of the argument, and it depends critically on both the release price mechanism, as it's called, and the LTV covenant. Now, there were in our submission two serious flaws in the judge's analysis accepting that alternative case. The first is, as I say, the LTV covenant only came into effect from the 1st of December 2024 onwards. Therefore, what the plan company had to do was to rely on this other provision called the release price mechanism. And it was said that this provision would prevent sales of the properties at low values in the period before the LTV covenant came into effect. Now, the problem with that is that premise is wholly undermined by what the judge said elsewhere in the judgment, that the new money lenders would waive the release price mechanism in order to allow sales at true market values, even if those values were lower than what the plan company was predicting. And you see that in 262, 263 and 265 of the judgment. And this was, I mean, essentially on this point, he accepted what we said to him, because we said, well, it wouldn't make any sense for the new money lenders not to agree to a sale that was at market value. They would be interested in getting paid as quickly as possible. They wouldn't care what book value was. They just want market value and to get paid. So as long as they can be sure they're getting market value, they're likely to consent to the release price mechanism being waived.
They've got first security over all the property assets.
Correct, they've got first ranking security.
Yes, but I mean, their debt is 900 and something million.
Yes.
And they can look to 7 billion of assets to have that paid? Or?
Well, in theory, yes.
So actually they don't care whether they're sold for high values or low values. As long as they've paid for 900 million, that's enough.
They don't care, exactly. I mean, you could make the argument they wouldn't even care that it's sold at market value. But we don't.
He's made a finding to the opposite effect, which I haven't quite understood. What was the basis for that finding?
Well, I don't know. I mean,
I suppose the new money providers all have interests in the sons as well, don't they?
Possibly. Yes, I mean, that's true. So they would have that collateral interest as well. But I mean, I don't need to get into that territory, because for the purposes of my point, I can just rely on what he said here, which is that the new money lenders would waive the RPM, release price mechanism, to allow a sale at market value, even if the market value is less than the book value. And I mean, that does make sense. But the problem is that then undermines entirely the enforcement scenario, because you're then in a world where there will have been disposals of property at potentially quite low value before you get to the 31st of December 2024. So that's...
Well, sorry, I'm struggling here. He's saying that they would waive it if the asset was being sold at market.
Yes, that's what he was saying, yes.
Right, so your complaint is that the sale at market value is prejudicial to your clients?
No. No. So the premise of the alternative enforcement scenario is effectively there's two stages to it. And the critical point is that the LTV covenant doesn't come into effect until the 31st of December 2024. Therefore, what the plan company needed to say was, well, that doesn't matter because the release price mechanism will, in effect, operate to hold the ring to stop sales at low values taking place until the LTV covenant kicks in. And that was part of the
When you say low, you don't mean below market.
So below,
When you say low
As-
values,
at low value, so below book value in essence, in other words, below the values that have been attributed in the BCG report.
But properly marketed and sold at market value.
Yeah,
right?
exactly.
Okay, that's sorry. It's terminology again. Sorry, I was.
Yes, it's probably my fault. But
And the release price mechanism is something that's only in the hands of the new money holders, is it?
that's correct, yes.
Once they've been paid off, then wouldn't people wait until the market recovered?
Well, they might do, but in the meantime, you've lost what's potentially assets to the value of the new money at less than the.
But does that matter in the sense that you don't object to the new money providers having
No.
first ranking priority?
No,
So you can't object to them saying, well, we want
No,
assets
there's-
sold and us to be paid off. I mean,
no, to be clear, this isn't an objection. I'm just what it is a reason why the logic of the alternative enforcement scenario doesn't work. We're not objecting per se to this. What I'm explaining is that the alternative enforcement scenario essentially has two elements to it. Firstly, they say that for the period to 31st December 2024, there won't be any sales of properties at low values because the release price mechanism will stop that happening. And then they say, from the 31st of December 2024, if the property prices drop, the LTV covenant will be triggered. And at that point, you'll have an enforcement and everyone will be treated pari passu. So the two limbs.
why do you need the first limb? I haven't understood that. So suppose the asset values are as low as Knight Frank suggested. The new money holders, as you have this finding, that they will waive the release price mechanism to, as long as they're satisfied that those low values below book value are in fact market value,
Yes.
until they're paid off. So you do that all takes place in 2024 before the loan to value covenant kicks in.
Yes.
But there's no further sales once you've paid them off. I see that may mean that quite a lot of assets have been sold at low values,
Yes.
but you can't object to people who have a first ranking security wanting to be paid as long as they're sold at profit market value. So that what you're left with on the 31st of December 24 is whatever you're left with. That may be less than it might have been, but it's still whatever you're left with. The loan to value covenant will then kick in, and then everything else is pari passu.
I don't disagree, but
So why don't you end up with
because
a pari passu distribution? You do.
no, because the financial analysis they put forward, which produced an estimated percentage return to
Oh, I see.
depended on there not being sales at low values in that period. So the analysis effectively assumed, as part of working out the financial figure, that you wouldn't have sales at less than the BCG values for that period. So you could say, well, actually, it's not necessary to make that assumption because it would work perfectly well without it. And possibly that's right, but then you would produce a different figure potentially coming out as compared to the one they did produce. So the issue is they produced this figure of saying, well, you'll get 63% in the alternative enforcement scenario. One of the premises is underlying that figure is there wouldn't be sales at low values in that period, and therefore when you got to the commencement of the LTV covenant, you'd in effect have a full pool of assets at that point in time. And we say that's wrong because actually what the judge himself found was that as long as a sale was at market value, it would be likely permitted by the new money lender. But the second point, in any event, is that the key part of the judge's analysis and the reason for the difference between the enforcement scenario and the liquidation was that the sale of properties in the enforcement scenario would not attract an insolvency discount, which it was said would be applicable to sales which took place from within a formal liquidation. So in other words, the reason why the alternative enforcement scenario gives you a better result than the liquidation is just because you don't get the insolvency discount in the enforcement scenario. But as we say in paragraphs 55 and 55.4 and 55.5 of our skeleton, that doesn't make any sense because the judge's enforcement, the alternative enforcement scenario assumes that the debt is all accelerated in order to make a distribution. And if the debt is all accelerated, why wouldn't the company go into an insolvency proceeding? And indeed, as we say in 55.5, the plan company's own evidence was that in the event of acceleration, the group company's directors would have no option but to file for insolvency with the resultant insolvency effect discount on asset realisations. So for this reason also, the alternative enforcement scenario doesn't make sense, or logical sense, because it presupposes an acceleration of the debt. Well, that would obviously be part of an enforcement, but if there's an acceleration of the debt, the plan company itself was saying, well, we'll have to go into insolvency then. So why is it that the enforcement scenario leads to a better result without the insolvency discount than the liquidation scenario?
I mean, you're saying that in the enforcement scenario, it's the enforcement of security. So it's not strictly a sort of insolvency discount, it's a sort of forced sale discount in that context, isn't it?
That's correct, but what was said is if you do it in that, what was said is if you do it outside of insolvency, you may not get the stigma discount of a sale in liquidation and that sort of discount.
But that is, you're saying, yes, but you would have in effect the same stigma discount because it would be an enforcement sale.
Or, not only that, but also the enforcement, as you can see from 55.4, the only way you can do the distribution is by accelerating the debt, because the debt's all of different maturity. So what my learned friend said to the judge was, well, you accelerate each series of notes, and then in those circumstances you would have a pari passu distribution because all the notes have been accelerated. And we say, well, that doesn't make any sense because if all the notes have been accelerated, your own evidence is that you would have to go into a formal insolvency proceeding. So, I mean, let me put it simply as I can. I mean, the alternative enforcement scenario depends on the acceleration of the notes.
Yeah.
But the evidence of the plan company is that the acceleration of the notes will lead to entry into an insolvency proceeding. So how does the alternative enforcement scenario help you by avoiding an insolvency proceeding, which is the thing that gives rise to the discount? And I mean,
are you any worse off in that situation than you would have been under the relevant alternative?
well, if there's no insolvency discount, then the two situations are potentially just neutral. But I mean, it doesn't mean it does wholly undermine the judge's conclusion that we're better off. And if that's the alternative, you would say, well, why don't we go into liquidation now?
What's the judge's finding that you're better off under the alternative?
Let me look what he. This is. So it's 292. It's the penultimate sentence of 292 on page 895. So the plan company doesn't deal with either of those points in its skeleton argument. I don't know what the answer is to them. The point it does make is in paragraph 59, where it says this point is irrelevant because the judge found that the plan creditors were most likely to be paid in full under the plan. And that goes back to the debate which we were having yesterday. And in our submission, that's not the exercise which the judge was doing. You can see that from 293 of the judgment. What he was doing was picking from the menu of options. And indeed, you can see the way he approached it in 292 and 293 that he regarded the analysis in 292 as being critical to his conclusion on the no worse off test. Now, the other criticism we make of the alternative case is the state of the evidence. We deal with this in paragraphs 56 and 57 of our skeleton. That evidence and analysis was wholly unsatisfactory and inadequate for the reasons we set out there. As I say, none of this was in the explanatory statement. What happened was it was put forward for the first time 5 business days before the hearing. There wasn't an expert report. We got a few slides exhibited to a further witness statement to Mr. Trotsey, who said we'd get 74.6% in this new scenario. That quickly turned out to be wrong in cross-examination because he accepted various errors in the analysis. We then produced a document which we called the cross hand-up, which was intended to illustrate some of the difficulties. It wasn't itself an expert report, it wasn't comprehensive, it didn't identify every point. And then the plan company sought to use that as if it was an expert report and say, well, aha, this proves the case, and that's what the judge then relied on in the judgment. So that evidentially that was unsatisfactory, and more fundamentally, none of this was ever put in the explanatory statement. Now, that deals with ground 7. Ground 8 I can deal with very quickly indeed. There is a blot on the plan. The reason there's a blot on the plan is that the plan doesn't purport to reverse or otherwise deal with the effect of the notes that were, that were accelerated prior to the sanction of the plan. And as you can see from paragraph 61 of the skeleton, around 185 million euros of debt was accelerated in accordance with the terms of the Sun before the plan was sanctioned. Those creditors who have accelerated their debts are free to assert them as debts against the group, notwithstanding the plan. That's clearly contrary to the scheme of the plan. It also brings into question whether the plan can achieve its objectives. The plan company's answer to this is to try and dispute the events of default. It says, well, there wasn't an event of default because Part 26A restructuring plans aren't insolvency proceedings. That's not a great point because the English court has held the contrary in the Gate Group case. And in any event, the judge didn't decide the issue on that basis. And there isn't a respondent's notice on that point. And in our submission, that is a blot on the plan because one is left with a position where some of the creditors within the 2029 Sons, notwithstanding the overall scheme of the plan, are left free to assert their debts against the parent and indeed the plan company. So looking at the time, I think I ought to probably sit down at this point, but those are my submissions on the ground of appeal.
Yes, there was the question we posed yesterday. If we were to allow the appeal,
Oh, yeah.
what happens?
Well, in our submission, the appeal should be allowed. The order sanctioning the plan should simply be set aside. That's the only order that this court should make. the effect of that is that the amendments which have been made to the sons affected by the plan would then fall away. So the sons would simply revert to their unamended form. The son holders would likely at that point be entitled to accelerate and assert their debt claims against the plan company and the issuer.
On the basis of breach of a negative pledge? Or
Yes,
what? Yes.
Exactly. I mean, at that point, it would then be a matter for either entry into solvency proceedings or the negotiation of an alternative restructuring.
I mean, the new money has gone in.
Yes. So it wouldn't necessarily affect the new money because that wasn't done under the plan, and there would be.
The new money there's a contractual liability to pay the new money and all the fees and the security and so on.
Exactly. Yes. So the setting aside the plan doesn't itself affect that liability or the security.
Well, it might depend on the terms on which the new money was advanced. I mean,
it might. I mean, I think that the technical position would be that if the sons revert to their unamended terms, then the new money security would have been granted in breach of the negative pledge.
To the knowledge of the new money lenders.
Yes.
So there might be a question.
There might be, but that would then, that would fundamentally be a question of German law, which would require litigating. It may be that the security would be considered to be valid, it may be it wouldn't, but that wouldn't be.
Anyway, your position is we simply set aside the order and we leave it to the company to work out where that leaves them.
Yes.
I mean, you presented it as if the order and the plan simply made amendments to the sums.
And there was an inter-creditor agreement that was put in place as well.
I mean, I understand your broader proposition, which is you just say, well, in a sense, it's for the plan company to figure out where it is.
Yes.
But assuming that we want to understand it a little bit, but we haven't actually looked at the plan.
No.
Or indeed the order sanctioning it.
Correct.
I mean, if this plan follows the, if the order and the plan follows the normal course, it authorises the execution of a whole suite of documents.
Yes. So, principally, what this plan did. I mean, you can see this if you go to page 62 of the core bundle 1. I mean, how it works is that, as your lordship envisaged, a pretty conventional form. So, clause 5 is probably the critical one, and that gives the authority to execute the amendment documents. And then, if you go to page 63, the amendment documents are essentially the agreements amending each series of sons. And then what is set out as exhibits or annexes to the plan are the amended terms of the sons, essentially.
I mean, I know this format has become more popular, shall we say, with the more complex restructurings. In the old days, the plan scheme would actually contain the terms of the scheme.
It would.
Nowadays, it seems to be that the plan or the scheme just says that authority is given to somebody to execute a whole raft of documents, including, I see, in fact, documents which, according to the definition, the plan company thinks are appropriate.
Yes.
Which is a long way from the old style.
It is. But I think what matters, I mean, for your purposes, perhaps is that, I mean, what would happen is if the order sanctioned the plan is set aside, then the authority to execute the amendment documents wouldn't have existed. So the amendments to the sons wouldn't have been made. So essentially the sons revert back to their unamended original terms. And that's all that happens as a consequence of this court's order. And then
the deed of release falls away as well.
The deed of release falls away. And then the consequences of that, firstly in terms of what the impact is on the new money, and secondly what the impact is vis-a-vis the group, would be matters to be worked out. And it may be the company would go into an insolvency proceeding. It may be that an alternative restructuring at that point. I don't think your lordships have any evidence on that, those possibilities. But I mean, our position simply is that if we're right on the appeal, as we say we are, then the normal order of the court is simply to set aside the order of the court below. Your lordships aren't being asked by the respondents to make some form of alternative order. I'm not sure what the alternative order might be.
So if, in the normal case, sorry, there is no normal case anymore in this world, but in a situation where the first instance judge said, "Oh, I'm intending to approve a plan," and an opponent wished to appeal, you'd normally, obviously you ask for permission to appeal, you'd normally apply for some direction that the plan not be made effective.
Yes.
Which wasn't sought in this case.
No.
If then the plan becomes effective, people act upon it. This isn't a case where money would go out of the company, the plan company, in reliance on the plan, which might often be the case if, for example, there was a straightforward compromise of debts, which would cause all sorts of problems with having to recover money paid under what would be a query a mistake.
Yes.
This is only a case where money essentially comes in to fund the operations of the group.
Yes, through the provision of the new money. Yes, that's what happens as part of the
And
plan.
the point being that, so the people who put the money in would have put it in at least knowing that the plan had been opposed, albeit that no stay had been sought.
Yes, and I think they would have known of the pending appeal, because I think we'd certainly made our intentions clear. Yes, we've made our intentions.
But it's not suggested against you that we can't make the order you're seeking because of some problem about the passage of time. So
quite, and the Nugee appeal point, as I said, it's done those submissions. I mean, that was expressly canvassed quite understandably by the court and effectively abandoned because the plan company didn't want to pursue it.
All right.
Thank you very much.
Thank you, my lord.
Mr. Mayfield,
Good afternoon, my lord.
you've got just over 10 minutes to make the killer points,
Lord, I will attempt to do so.
and then you can come back this afternoon and tell us why.
My lord, what I'd like to do is to, before I turn to the individual grounds of appeal, start with an overview of what the company's answer is to the appeal. And the starting point for that is to identify that the appeal relates to a complex, multifactorial, evaluative exercise of discretion by the judge to sanction a restructuring plan. And the sanction hearing took place on an expedited basis over 3 extended sitting days, during which the judge heard legal argument and actually live evidence from 7 witnesses as well. The sanction hearing concluded on the 5th of April 2023. The sanction order was made on the 12th of April 2023, and a reasoned judgment was then handed down on the 21st of April, 9 days later, running to 164 pages in length. And the relevance of that is that when reading the judgment, it is important and only fair to the judge to bear in mind the time frame in which it was produced, and it's important not to treat it as a statute. It needs to be read as a whole in its proper context and should be given a fair reading rather than being read in a way that occasionally my learned friend attempted to read it in, which was designed to undermine its internal coherence. And just on this point, can I take my Lords, please, to one Court of Appeal judgment in which my Lord Justice Snowden was part of the panel. It's a case called Volpe and Volpe, and you'll find it in the third volume of the Authorities Bundle at tab 33. There's just one sub-paragraph I would like to show my Lords and remind my Lord Justice Snowden. It's tab 33 and it's page 1020 using the bundle numbering. And it's paragraph 2, subparagraph 6. Reasons for judgment will always be capable of having been expressed better. An appeal court should not subject the judgment to narrow textual analysis, nor should it be picked over or construed as though it were a piece of legislation or a contract. And I just suggest that it is worth bearing that in mind in relation to certain of the points, including the basis upon which the no worse off test was held to be satisfied by the judge.
But it's an appeal against the exercise of a discretion, and conventionally they've got to demonstrate that the judge has misdirected himself, or at least has in some way committed a material error of law.
Correct.
Of course, a material error of law may be an actual misdirection, but it may also be the making of a decision which lies outside the reasonable limits of the discretion on a proper application of the law.
Precisely so.
Yeah.
Accept that.
But I think they accept that.
Yes.
That's the
Lord,
hurdle which they have to overcome. I mean, obviously, we wouldn't set aside the judge's decision because it hadn't been as well expressed as it might have been. If in substance it was a decision which was open to him on a proper consideration of the material.
Yes, my Lord, I think this is common ground between the parties, and exactly as my Lord has just put it.
Just
Yes.
Picking up what you said, I mean, I think you can take it as read that, certainly for myself, I intend to be extremely fair to the judge, who did I'll say now, a remarkable job producing a judgment of this length and detail in the time that he was given. A point is made, and I'd like to hear your answer to it. You indicated that he heard this appeal on a accelerated basis over extended court days, hearing a considerable number of experts on matters of some detail. Why was that?
Well, my Lord, as I understand it, I wasn't at the convening hearing. This wasn't my case at that stage. Directions were given at the convening hearing stage for a contested sanction hearing to take place in time for the new money to be borrowed.
When did the negotiations start?
Well, second half of 2022, there was a consent solicitation that went out in December 2022.
So, it's not as if the deadlines that you identified were unforeseeable. This wasn't a sort of coronavirus pandemic type case. This was a situation where the maturity dates and the debts to be paid were well known a long time in advance. How is it that the judge came to be faced with this mountain of material and this task with only 3 extended court sitting days within a very short range of the maturity date as an exercise that he had to perform?
Yes, well, it's a lovely, fair question. As I understand it, there were negotiations in the second half of 2022. They culminated in a deal being agreed between the members of SteerCo and the company.
When?
Well, the consent solicitation went out in December 2022, so I assume before then, or in December 2022. The consent solicitation went out, all of the classes voted in favour other than the 2029s, and it was therefore necessary for the company, if it were to consummate the deal, to do it through restructuring plan rather than consensually. and therefore in January 2023 the practice statement letter went out.
And so nobody had turned their mind to this before the consent solicitation or before the negotiations prior to the consent solicitation. I mean, you know where I'm coming from. This is not news to anybody in this area. That, for quite some time there has been this sort of pressure put on the court, which has only got worse with the valuation disputes in relation to restructuring plans.
Yes.
It was bad enough in relation to schemes, and Noble Group was a scheme in which I had something to say about this type of problem. Is there anything, I suppose what I'm really saying to you is, why was there no appreciation given at an earlier stage to the difficulties that a judge would face having to deal with this level of complexity in evaluation disputes, so that the judge would have been given a longer period of time to consider the complex issues in this case and to deal with the expert evidence in an appropriate way?
And my Lord, can answer that in two ways. The first way is to say, I can ask the question of those behind me in relation to what happened in 2022 and what thought might have been given to the situation before then. I can't tell my Lord the answer because I don't know. The second way of answering the question is this, that at the convening hearing, I think it was, I wasn't there, I think it was agreed, Mr. Smith will tell me, or the judge directed that a 3-day time estimate should be sufficient to deal with the sanction hearing. He was working backwards from when the new money was required to be received to pay the Adlery 2023.
The judge, if I may say, went above and beyond the normal judicial call to accommodate this hearing and to shift heaven and earth to produce a decision in this judgment. That's obvious from just looking at it.
Yes.
The question is whether he should have been in that position at all.
Well, my Lord, and I'm trying to answer that, but not with first-hand knowledge and not at the time having known whether there are any other options. But what I can say is that between the convening hearing and the sanction hearing, the case did mushroom, if I can put it in that way, with a raft of points being taken, including on valuation, including on German law, including on the insolvency discount, including on the pricing of bonds, and so on and so forth. And that led to the judge's plate being, I suspect, even fuller than Sir Anthony Mann at the convening hearing or counsel at the convening hearing would have imagined. And as my Lord says, the judge at the sanction hearing did what he considered was doable in the time available to give a decision in relation to the restructuring plan. It was, for all concerned, of course, especially the judge, an exercise which was done in a time period which was inadequate. It was considered necessary because the evidence was, if it wasn't done within that time period, then the restructuring would necessarily fail as a result of actions that might be taken by the holders of the Adlery 23s. And therefore the judge did what he could, as everyone did. With the benefit of hindsight, of course, things might have been done sooner. I'm speculating, I don't know. The judge was put, as lots of us were, in a terribly difficult position. But my Lord, not having been involved in the case until after the die was cast and the directions were set, I'm not sure, without taking instructions, I can do better than that in answering my Lord's question.
Okay. I mean, you'll know the point that I made in Noble Group, which I have to say this case seems to only reinforce is that parties to commercial negotiations of this type, where restructuring is envisaged because of the imminence of maturity dates for complex financial instruments, have to start the preparation and the negotiations a lot earlier, and they can't just, as it were, run their negotiations to their own timescale and then throw a mass of stuff onto the court's plate at the last minute and expect a judge either to do what this judge went out of his way to do, or alternatively to produce a faultless judgment.
Yeah, my lord, I entirely agree with that. I should say that there may be some responsibility, I'm not talking about this case necessarily, but in general cases where people oppose restructuring plans and schemes, that they take the points that need to be taken and don't overburden the court with arguments that are arguments that don't need to be taken. But my lord, I can't possibly suggest that what my lord has just said in terms of the burden that is put on the judiciary and the efforts that those advising clients need to go to avoid that there is a problem in that respect. But equally, there will be situations, the coronavirus is a good example.
There undoubtedly are.
Where nobody is in any way to blame for the situation which arises in terms of urgency and the pressure that it puts on the judge. There will be other cases where it may be different.
Yeah.
My lord will remember dealing with the case of Recoloros, where the bull was taken by the horns very early indeed, I think about 18 months before maturity, in circumstances where it was said that it would be very difficult to refinance and therefore something needed to be done and it was better to come and do it at that stage rather than later. That's certainly something which is to be encouraged because it would put less pressure on the timetable and then therefore less pressure on the judge. Not every situation will be capable of being done like that. And I think the other point, and this is a point that should be taken into account really, is that companies that are in financial distress are not in a position to come to the court sensibly with a plan or a scheme until such time as they have sufficient support to consider that the time and money involved in promoting that plan or scheme is going to be well spent. The company, therefore, very often, the debtor group, is somewhat at the mercy of the groups of creditors that form to negotiate
And
in terms of restructuring. But until you've got an executable, deliverable, however you want to put it, restructuring, you can't send out your PSL and you can't issue your claim form and you can't come before the judge. So,
well, with respect, I mean, that in a sense, I understand entirely your point about the position of the planned company. And in this case, my clear impression is that you are saying you are very much in that type of situation, because here there were a number of different groups of creditors. If I can put it colloquially, is were squabbling amongst themselves as to how to divide up a restructuring surplus that everybody wanted to generate from a plan of some sort. In other words, everybody realised that the worst case scenario was a formal insolvency. Everybody wanted a restructuring which generates benefits for everybody. And the problem in the case of this type is that there are different creditor groups with different interests angling to advance their own interests in negotiations between themselves.
yes.
And that's my impression, clear impression. We haven't looked at the evidence such as it is on this, but that's the clear impression you get. And so, as it were, the fire, if there is fire to be directed, you're saying to be directed in a situation like this as much as to the warring creditor groups or as it is at the planned company. Yes?
Well, I'm not trying to turn the fire on anyone else. I'm simply trying to deflect some of the fire from the company.
I mean, certainly for myself, I think this sort of point needs to be made and reiterated again, because it seems to have been either the message seems not to have been taken on board by those who are in the restructuring community or their clients. And the consequence of which is we have an appeal like this, and we have valuation disputes which are becoming more prevalent. And something needs to be taken on board. So I'm just testing with you where the problem may originate.
Yes, and my lord, I understand that. From the advisor's perspective, one can tell clients that. What the result is of clients being told that will depend on the client. Equally, sometimes negotiations take longer than people expect. Plan companies are reliant on experts to give their comparator reports and all of the rest of it to be appended to the explanatory statement. That will take time and needs to be got right. These deals do take, through the negotiations and the paperwork, considerable periods of time. All of the advisors know that, and all of the advisors should be working to convince their clients, whether they are ad hoc groups who are helping to negotiate the deal, or the debtor group, or whoever. People should be advising that these things take a long time to get right, and negotiations need to happen, and therefore the earlier one starts, the better. But there's no question about that, and the less pressure that can be put on the court and on the advisors and the advocates, the better. But situations do arise where turning no fire on anyone because it's not necessarily anyone's fault, plans come before the court later than would be ideal. And when they are challenged in the way that this plan has been challenged, in the way that Virgin Active was challenged, in the way that another plan is going to be challenged at the end of November, and there are countless other examples, it necessarily does put pressure on the judge as it does the teams working behind the scenes. All we can do as advisors is continue to say to our clients, this is causing a problem. You're putting everyone, including the judge, under too much pressure. We need to take the bull by the horns sooner. It's very difficult to see what more can be done than that. And it's also difficult to see what more the court can do, because if the judge is faced with evidence that unless a decision is given by a particular period of time, the benefits of the restructuring will be lost, then the judge's natural inclination, and rightly so, will be, where possible, to give a decision by that date. And if that means sitting for extended days and not hearing live evidence from every witness to achieve it, like in this case, then that is imperfect, but better than an alternative which involves everyone being worse off. Now, I don't know.
In the last resort, you can't complain if a judge says, I am not in a position to resolve these issues by the deadline, you've left it too late, you won't get a decision. But, as you've just said, no judge wants to be in that position. But if you were in that position, you couldn't really complain if you leave it very late.
Yes, when my lord says you the company, or you the ad hoc group, that's fair.
But what shouldn't happen is that the judge is pressured to sanction an unfair scheme, an unfair division of the restructuring surplus, simply because if he doesn't, everybody will be worse off.
Well, I mean, no judge is forced to do anything.
But that's the gun to the head that I have spoken about judicially previously, where the judge is told, if you don't sanction this scheme or this plan, Armageddon will happen, which is worse for everybody. Therefore, you must sanction the plan. That can't be an answer to fundamental unfairness in the plan, surely. I mean, the point is, the Parliament doesn't envisage the sanctioning of a plan which is unfair as between creditors just because everybody will be better off.
Well, I
than
think,
the alternative, which is presented as the only other option at the last minute.
yes, I mean, my lord's moved away from, I think, a timing point.
Well, no, it's not. I haven't moved away from the timing point. It's exactly the timing point. If you leave it to the last minute, you tell the judge there is no
Yes, I see.
chance to do anything else. It's this plan or Armageddon. Which one are you going to choose, judge? And if the judge is faced with Armageddon or this plan, if the plan is unfair, the judge is faced with at the last minute with saying, well, I'll have to sanction an unfair plan because Armageddon is the only other alternative. That cannot be what Parliament intended this legislation should achieve.
No, well, I'd have to accept that, my lord. But in an ideal world, every plan that's presented would be fair and that wouldn't be an issue. If someone proposes a plan which is on the cusp, let's say, if they do it in sufficient time for a better, fairer plan to be promoted if the first plan fails, well then the judge may be emboldened to decide it in favour of refusing sanction. I think the point that my lord is making is that companies shouldn't benefit from leaving an unfair plan until the last minute so that there is no possibility of promoting a better plan and then holding the gun to the judge's head. That is right. I'm not saying that is the answer to this appeal. At the moment, we're talking in general terms.
We are.
Mr. Fairfield, I think we'll allow you to go and have some lunch. We'll resume at 2:15.
Thank you, Lord.